present. Councillors Ali Callison, Jerry Convery, Colin Dewar. Apologies from Councillor Gladys Ferguson-Miller. Councillor Elise Frames present. We have apologies from Councillor Leslie MacDonald, and Councillor David McLachlan is attending as a substitute. And the following members are also present: Councillors Richard Nelson, Norman Ray, Graham Scott and David Shearer. Thank you, and I'll pass you back to the Chair for today's business.
Thank you, Stuart. We'll just go into today's business. Item number 1 is any declarations of interest. If there is no any declarations of interest, agenda item number 2 are the minutes of the previous meeting, which are on pages 5 to 18. These are submitted for approval as a correct record. I will move these as a correct record.
I'll second it.
All agreed? Thank you. Agenda item number 3 is review of case in respect of planning application P230863, pages 19 to 178 in your pack. This item is a notice of review from Padrino Design on behalf of Mr Hugh Burns. The applicant is asking the PLRB to review the planning officer's determination to refuse planning permission for the change of use of a forecourt to form an external seating area ancillary to an existing cafe premises at 270 Stonelord Road, Rutherglen. I'll hand over to the planning advisor to give members an update on a procedural matter in relation to this case. Tony?
Thank you, Chair. Just by way of background for members, under planning legislation, when making a planning application, the applicant must certify on the application form whether they own the application site or not. In cases where they do not, they're required to serve an ownership notice on parties that do have an ownership interest. Also, where the ownership of the site is not known to the applicant, the council must place an advert in a local newspaper. In this case, the applicant certified when he made the application that they did not own the application site and they did not know who owned it, and therefore a press advert should have been arranged in this case. It's recently come to light that advertisement did not take place during the processing of the original planning application. And in detail, Regulation 20 of the Town and Country Planning Schemes of Delegation and Local Review Procedures Regulations 2013 states that where requirements for the processing of plan applications have not already been complied with, the local review body must ensure that these are carried out before determining the review. In this case, the PLRB must ensure that the required publicity in terms of the press advert is carried out before the review can be determined. So, as a result, the determination of the review today should be deferred to allow the publicity to be carried out. And once that's been done, the case will be reported to a future meeting of the PLRB. Back to you, Chair.
Thank you, Tony. I'm going to open up to see if any members have any questions or comments to make. If there are no questions or comments, having listened to the planning advisor, I will move that this case then be deferred for consideration at a future meeting of the PLRB. This will then allow the application to be advertised in the local press, referred to by the planning advisor, in accordance with the requirements of Regulation 20 of the Town and Country Planning Regulations 2013. Is anyone else otherwise minded? I'll move that.
I'll second it.
All agreed? Okay, the clerk will now then write to the applicant's agent and interested parties advising that a review has been deferred. We will move then to agenda item number 4, which is the review of case in respect of planning application P231273, pages 179 to 282. The item before us today is a notice of review from AD Plans, LDT, on behalf of Mr Graham Gracie. The applicant is asking the PLRB to review the planning officer's determination to refuse planning permission in principle for the erection of a detached dwelling on the land at Southfield Road, Southfield, Blackwood, Lanark. I understand that there is a procedural matter that requires to be considered, and I would invite the legal advisor to provide details of this before the planning advisor describes the background to this review. Sean?
Concerning late submissions from the applicant. Now, these concern the applicant's comments on further representation submitted by interested parties in the course of the notice of review consultation process. And if I could ask, Chair, for the committee to turn to page 281 of their pack. And on the first line, it reads, firstly, the question of brownfield vacant derelict land, please examine the photos provided. Now, at that point, Chair, the photos weren't provided, and the photos were only just provided yesterday. So it's a matter for committee's discretion as to whether to view these photographs or not. Thank you.
Thank you. I'm minded to allow these photographs to be distributed to the committee, the PLRB. Is
I'll second that, Chair.
everyone agreed? I don't intend to adjourning the committee meeting. I will ask that these are now sent round by email for those who are online, and in the room I will ask that the clerk will distribute these. Thank you. I'm going to then I ask now that the planning advisor describe the background to this request for a review to the members. And I'll ask Tony just to, oh, sorry, Mike. Sorry. Michael?
Thanks, Chair. The applications for planning permission in principle was refused in December 2023. The report of handling sets out the reasons for refusal. These can be summarised as: the proposal is contrary to National Planning Framework 4, Policy 17, Rural Housing, because the site does not meet any of its criteria. Specifically, Part A, Criteria 2, there is a history of housing on the site some decades ago, but the house is no longer there. The site returned to a natural state. Therefore, the site does not constitute brownfield land, where a return to a natural state has not or will not happen without intervention. Nor does it meet Part B of Policy 17 on locating new homes in rural areas. This is because it does not contribute to local living, which is set out in detail in NPF Policy 15. So on NPF Policy 15, because local services cannot be reached safely by foot, dwelling on this site would result in a dependence on the private car. Therefore, it doesn't contribute to local living. It also does not comply with LDP policies, specifically Policy 4, because there is no requirement for a dwelling to be located in this countryside. It cannot be approved on the basis of GBRA 6, because the policy deals with replacement houses and does not apply to substantially derelict or demolished properties. Finally, it is contrary to policy LDB Policy 5, because the road service has objected, questioning the ability to make a safe road junction in this location. I'll just now bring you through the applicant's notice of review, which can be summarised as: in terms of NPF Policy 17, rural homes, Criteria A should apply. Housing, although now demolished, was once situated on the site. It meets one of the policy criteria because the land cannot return to a natural state owing to previous housing foundations on the site. In terms of NPF Policy 15 on local living, there are many small housing groups in the area. The new dwelling alongside the adjacent house would reflect this pattern. The site is within 5 minutes walk to Blackwood and Kirkmuir Hill and their local services and transport links. Residents can use the existing road to walk to these services. In fact, local residents already walk such roads in the area. In terms of a response to Policy 16 of NPF, the location is correct for a high quality, low density house. It would be adjacent to another recently built house on the former row, once known as Southfield Terrace. And in terms of the LDP policies, the sites would not contribute to an unnecessary spread of development in the rural area. This is because it's confined to the location of a former house which once stood there. There's a need for housing of this type in the rural area of South Lanarkshire. And finally, the applicant considers the roads objection can be dealt with by a condition in any subsequent application for full planning permission and enforced thereafter. I'll hand back to you now, Chair, to carry out the review.
Thank you. The first point for the PLRB then is to consider and decide how to proceed with the review. The applicant has indicated that they consider that the review can proceed based on the information provided by them and other parties, and no further procedures are then required. However, the applicant has advised within the supporting statement that members of the PLRB visit the site to determine if the site has returned to a natural state. Taking account of what is in our papers, we have to decide whether they do in fact contain sufficient information for us to determine the review today, or if we need more written information, a hearing or a visit to the site. I think that all the information that we have, plus the detailed photographs we have of the site, does provide us with all we need to consider this review without either a site visit or a hearing or further written submissions. Do members therefore agree that we can proceed without a site visit, hearing or additional information?
Agreed.
Anyone otherwise minded? Okay, they will then proceed to the review, and I will now open up for any discussions or comments to be made. Online we have Councillor David McLaughlin first, please.
Thank you, Chair. Can I just get some, maybe ask the, I forget the person's name there, the previous speaker, to elaborate a little, because part of the reason is that you can't walk to the site, but the applicant has said that there is a road there. So can you explain to me why, in your opinion, you can't walk to the site?
I'll bring Michael back in.
Thanks, Michael.
Yeah, so the planning officer's interpretation of this and the Roads and Transport Service commented to the same effect. Yeah, so the planning officer and the Roads and Transport team both commented to the same effect, that as there's no pavement, no street lighting, etc., that it's not a serviced site in that terms, that it's not a safe route to walk through to the services of the local villages. So that's where that statement comes from.
Thank you. Councillor Alec Allison, please.
Thanks, Chair. Before I go on, you're then saying that there can be no housing in the rural area because we simply do not have pavements, etc. The road is what is used for access. Although I don't believe in this 20-minute rule in the rural area, it seems to be accessible. Services are accessible within that period of time here. But my main concern here is the designation of the site. Even before these photographs came in today, it was quite clear that it wasn't reverting to a natural state. And with the photographs, you see that the ground would need substantial intervention to be able to allow it to return to a natural state. And I'm really concerned that we're turning this one down, because as the applicant has said, roads, we can condition displays. Safety is an important issue, but to base this on an assertion that is not correct, I'm really concerned about. I don't know if there's a question in that or not, but I think I'm going to move to approve.
Thank you, Councillor Allison. I'll come back to you just in a moment. I'll keep that in mind. I'll bring in Councillor Elise Frame first. If anybody else would like to speak, can you indicate now? Councillor Frame.
Hi, thanks, Chair. It was just to come in with the same points as Councillor Alec Allison. As somebody who stays in Blackwood, I walk the area quite often, and so does quite a lot of people stay in Blackwood, Kirkmahill, and all the roads at these houses are all the same. So we're going to turn around and turn down something because of the roads. As Alex says, we're not going to approve any of them in the rural area. So I'd be hoping to go along with Councillor Allison and move that to be approved. Thanks.
Thank you, Councillor Frame. Councillor Graham Scott, please.
Thank you, Chair. Some of my points are very similar to Councillor Allison and Councillor Frame in terms of, I think they've made very good arguments. But the point I want to make, and I'd like the planning officer to elaborate more on the Roads Department objection on the visibility displays and explain again, I think it was something from, it's in the papers from the applicant, that this could be looked at the next stage of the planning process in terms of the roads. I mean, I'm inclined to support what Councillor Allison and Councillor Frame have said, but only if I'm convinced that there's no danger in relation to what the Roads Department have objected to. So could I have more detail on the Roads Department objection, please?
I'm going to ask Tony just to come in on that, Graham.
Yes, thanks, Chair. Yeah, the roads consultation response did advise an objection on the grounds that the applicant hadn't been able to demonstrate that the visibility display requirements could be achieved in this particular case. I think there's been reference made to the existing house next door and why that application being granted and this one had an objection. When we look back at the history of the house next to the site, at the time that application was made, all of the land, including the fields either side of the site, were in the ownership of one single party. And so therefore, the same sightline requirements were requested at that point, but because the applicant at that point owned the land that was needed to control the sightlines, that was acceptable. That isn't the case here. It looks, certainly from the information that's been provided with the application, that the applicant only owns the application site and doesn't have control over the land that's needed to satisfy the sightline requirements. Having said that, because this is a planning application principle, we could deal with this issue if members are minded to grant consent here through a suspensive condition, whereby if an application to deal with any matters specified today could require that sightline issue to be resolved at the detailed planning application stage. So hopefully that answers Councillor Scott's question there.
I think Councillor Scott had a supplementary.
Yes, thank you, Chair. That's what I suspected, that the applicant doesn't have control over the means of sorting the problem that has been indicated by the Roads Department objection, which means, am I right to conclude that at this moment in time, there's obviously there's something fundamentally unsafe, and that the Roads Department objection should stand, and that the applicant has no means of altering the situation that could make the situation safer in terms of a visibility display? If Tony could come in on that as well. Sorry for passing everything on to Tony, but obviously I think it's a very important point.
Okay, I'll ask Tony just to confirm.
Yes, thanks, Chair. So you're right, Councillor Scott, in that the applicant was advised of the roads requirements for sightlines. They haven't demonstrated that they'll control the land required for that to be provided. But as I said, because this is a permission in principle, if it had been a diesel application, might have been a different matter, but because it's a permission in principle, we can add, if members are minded to grant today, a suspensive condition requiring this issue to be resolved at the detailed planning application stage. So there is a backdrop to all that.
Thank you, Tony. Councillor David McLaughlin, please.
Thanks, Chair. It's coming back to the question of the road and the access. On the papers, you can see that the road is right on the frontage. It doesn't show that on the photograph, but you can see the house next door with the car, so it's very close to a road. And getting back to the point that Councillor Alec Allison had made, all of the rural area, I can think, you don't need to go rural, just at the top end of Hill House in Blantyre and Hamilton. There's lots of houses, there's lots of roads where you don't have footpaths or lighting. So I'm just a bit puzzled as to why this decision would have been made. It's right next door to an existing property, which has obviously had planning consent, and it's a relatively modern looking building according to the photographs I'm looking at. So I'm just a bit confused as to why you'd have come to this conclusion. Can I ask the planner to elaborate on that, please? Tony.
I'll ask Tony, do you want to, or Michael, just to come in and give a comment on, and then we'll bring this item to a... Tony?
Yes, thanks, Chair. I think it's probably worth describing the background to the house next door. That was granted back in the mid-2010s on the basis that it was a replacement house for a house was already on that site. So the circumstances are different to this particular stage. It was a like-for-like replacement. And I think in the meantime as well, National Planning Framework 4 has also become part of the development plan. And that also brings a different context to looking at applications like this. So there's been a bit of a sea change since the last application was determined, and in particular in terms of the reasons why that was granted in the first place.
Okay, thanks, Chair.
Thank you. Tony, can I just ask, if we allow this building at this location, does that mean that further down, because that then becomes a settlement, that we can't then, and we need to take every application its own merits, but does that give consideration for any future buildings on the land next to it?
Thanks, Chair. As you pointed out, every application is determined on its merits. As things stand in the local development plan, the site's within the rural area. So, and as with the assessment of this application, there is a strong presumption against new development in the rural area, both in terms of the LDP and also MPF4. So a justification would have to be provided by the landowner or the applicant at that time to demonstrate why an exception should be made. So it's hard to say if we could say yes or no to future applications. We'd have to determine it on the basis of the information provided. But certainly on the basis of what's there at the moment, it would be very difficult, I think, to justify further development in this location.
Thank you, Tony. If there's no further questions or comments, I will then summarise the points made. The application is for planning permission in principle for the erection of one house on land 36 metres south-west of 139 Southfield Road, Blackwood, Lanark. The adopted South Lanarkshire Local Development Plan 2 identifies the site as being within land designated as a rural area of South Lanarkshire. If we consider that there is no valid policy justification to support the erection of a dwelling house at this location, and it would not accord with policies 15, 16, 17 of NPF4 and policy 4, 5 and GBRA 6 of the adopted South Lanarkshire Local Development Plan 2, permission can be refused. Or, if we consider that there is adequate justification for the erection of a dwelling house, we could grant planning permission subject to conditions. Our options here today are to uphold, reverse or vary the planning decisions. I will now open up for any decisions and the reasons behind these decisions. Councillor Alec Allison.
Again, Kilmarnock, I am going to propose that we overturn the planner's decision here and approve the site on the basis that it has been misrepresented, the site. It will need significant intervention to allow it to return back to a natural state. And as I said, I don't really agree with the 20-minute rule, but I think it also complies with that. And I do not believe there is another use for a derelict site in this area. So I would propose that with the roads condition as suggested, that we approve this application.
Thank you, Councillor Allison. Councillor Elise Frame, please.
Hi there. Hi, Chair. Thanks. Just to echo Councillor Allison, I would move to grant this with the conditions of the roads. Thanks.
Okay, Councillor Elise Frame. Just to confirm, you're seconding that motion from Councillor Alec Allison.
Yes, I am. Sorry. Yes, I am, Chair. Thanks.
Thank you. Is there any further amendments? Is everyone minded to grant the planning permission?
Agreed.
Agreed? All agreed? Okay, I will then ask that we adjourn to 11 o'clock to allow the conditions to be passed around, and we will meet back at 11 for time to review these. It seems there's better reading in these, so we'll make it 11:05. You've got an extra 3 minutes. Okay, so 11:05 we will meet back again to go over the conditions at then. Okay, so 11:05, thank you. Thank you, and welcome back to the PLRB committee. Can I just ask if everyone has had a chance to read the conditions and reasons, and if we have any questions or comments to make regarding these? If you do, could you please indicate now? Okay, therefore, the decision of the PLRB to grant planning permission subject to the agreed conditions. The next stage is that a written decision notice will be issued by the PLRB, and this should be issued within 28 days. Thank you. We'll then move to agenda item number 5, please. So agenda item number 5 is review of case in respect of planning application P230788. It's pages 283 to 410. The item before us today is a notice of review from Barry McMillan on behalf of Mrs Maureen Gaffney. The applicant is asking the PLRB to review the planning officer determination to refuse planning permission for the erection of a equestrian stable block for private use, formation of access road with associated parking and turning area and associated fencing at Bigger Road in Symington. I'm firstly going to ask the planning advisor to describe the background to this request for a review to the members.
Thank you, Chair. So, as you said, this review relates to the refusal of an application for the erection of a stable block and associated works on land at Bigger Road in Symington. The site itself sits in an open field outside the settlement boundary of Symington, within the rural area. And as an aside, the applicants have indicated the stables would be for their own private use. The report of handling in the papers sets out the reasoning for the case offer to refuse the application, and these can be summarised as follows. Firstly, the proposal will be contrary to Policy 29, Rural Development of MPF4, as it does not meet the criteria set out in Policy for Rural Development, and it hasn't been demonstrated the proposal contributes to the viability, sustainability and diversity of the rural community or the rural economy. Secondly, the proposal will be contrary to Policy 4 of South Lancashire Local Development Plan 2, Greenbelt and Rural Area, as it is not an appropriate use in land use terms, namely a staple for private use with no identified residential dwelling to utilise it or to provide suitable attention and supervision to the animals. And finally, the proposal will be contrary to Policy 15, Local Living of MPF4, as it fails to allow daily needs to be met within reasonable distance of their home and create connected and compact settlements and mixed-use neighbourhoods. The appellant's notice of review provides their reasons for seeking the review, and these can be summarised as follows as well. Firstly, the applicant advises that planning permission has been granted for 3 houses to them on land adjacent to the stables, and that they will live in one of them. The stables would be for their own private use and potentially the occupiers of the other 2 houses. Secondly, the applicant has friends and family living in close proximity who could provide supervision of the stables while there isn't any from the applicant's side. Thirdly, they submit that a condition could be used to require that any works on the stables would not start until at least one of the approved dwellings adjacent to the site that I mentioned has started construction. And finally, they advise that the design of the proposal is suitably scaled and sited. It incorporates any energy-efficient features, and biodiversity will be enhanced through the provision of new planting and a wildflower meadow. So, in determining the review, there's several policies that are relevant to this application, and they're the ones I've just described there in my summary. So that's Policy 15, Local Living, and Policy 29, Rural Development in MPF4, and also Policy 4, Greenbelt and Rural Area in LDP2. I'll hand back to you, Chair.
Thank you very much, Tony. The first point for the PLRB then to consider and decide is how to proceed. The applicant has indicated that the review can be carried out based on a review of the relevant information provided by them and other parties without any further procedures. Taking account of what is in our papers, we have to decide whether they do in fact contain sufficient information for us to determine the review today, or if we need further written information, a hearing or a visit to the site. I think that all the information we have, plus the detailed photographs we have of the site, does provide us with all we need to consider this review, without either a site visit or hearing or any further written submissions. Do the members therefore agree that we can proceed without a site visit, hearing or additional information?
Agreed.
Anyone otherwise minded? Nope. Okay, we will then proceed to review, and I will now open up for any discussions or comments. If you could please indicate now. Councillor Alec Allison.
Sorry. Quite unsure about this one, Chair. Looking at the refusals, policy
Councillor
29.
Alec, can you just see if your microphone just comes up a wee bit
Oh.
closer?
Sorry. Is that better? Tell me when.
Yeah, you're near it.
That's a wee bit better, yeah.
Yeah, sorry, I've turned it up again. It was kind of loud earlier on. Right, we were unsure about the reasons for of what you've said regarding the reasons for refusal. Policy 29 does not meet the criteria. Well, where would you put stables? You wouldn't have them in an urban area. It has to be out in the rural community. Second one, proposed contrary to policy 4, not appropriate in land use. No identified residential dwelling, 2 points there. In the past, we've complained about there being a house associated with stables being built. And here we're saying that it's a problem that there's not a house attached to it, although they do have planning permission for the site next door. Pros contrary to policy 15, allows daily needs to be met within reasonable distance. Well, my knowledge of that site, the nearest shop's 5, maybe 10 minutes walk. It's certainly not out with the 20-minute neighbourhood, although they would love to have a train station within 20 minutes. It's not there. There is a bus goes past within 100 yards, I think, of this site. So I'm not sure that these reasons for refusal stack up. Don't know if the planners can give us any greater insight into why they've refused on these grounds.
I'll ask Tony just to come in. Alec?
Yeah, thanks, Jess. Thanks, Councillor Allison. I suppose my role here is to try and interpret what the case officer's intention was behind the decision that they made. And I think in a nutshell, it appears to be that these stables, they're for private use, but they're not next to the house that of the house that would be occupied by the owner of the stables or the horses. So in that sense, that would in turn lead to additional trips, which wouldn't comply with sustainable development and sustainable transport principles. If there'd been a house, or if the applicant's house had been next to the stable site, then that would have been obviously a different matter. But the interpretation of mine is that the case officer doesn't believe that's the case, and therefore it wouldn't be a sustainable development. Hope that helps, Councillor Allison.
Thank you, Tony. Tony, could I just ask, if this was rather than a question sent, if it was more of a business, would that give more of a weight to an approval rather than the officer's determination for refusal? Would that make any difference if it was a business rather than just a...
Yeah, we would look at things in a different manner. We have policy in LDP2 that requires for situations where an equestrian or a rural business is proposed and a house is requested to supervise that business, that there has to be a business case provided to demonstrate that it's viable, and also that on-site supervision is required. So there's a very different approach taken to the assessment of those proposals.
Just as I thought, thank you, Tony. Councillor Allison, please, and we'll bring it to a close.
Sorry, just to come back in, Chair. I thought it said in the report that the applicant was going to be staying in one of the 3 houses adjacent to these stables. Did I pick that up wrong?
Yes, thanks, Chair. Well, based on the information that's been provided by the applicant, you're right, Councillor Allison, the 3 houses that sit several hundred metres to the south of the site are on land that owned by the applicant in this particular case, and they have indicated that when they're built, they would live in one of those houses, so that therefore the supervision would be there. they've also potentially said that the occupiers of other two houses could also use the stables for their own private use. But from a legal point of view and from a condition point of view, it would be very difficult to tie that element up to ensure that that the house was occupied by the applicant in this case. So there's a wee bit of a uncertainty there.
Sorry, Chair, again, could I
Supplementary?
just... Sorry, Chair, aye. So therefore, are you suggesting that perhaps if the houses were built and they had moved in to one of these neighbouring properties, that this could then be looked at again with a different eye?
Yes, thanks, Chair, and thanks, Councillor Allison. So, as I say, I'm interpreting the case officer's view, but yes, the whole reason for the refusal was that there wasn't any local link to a house or supervision. If the owner of the stables lived locally, and one of those houses would probably count as local, obviously, then the outcome may have been different, but until we get an application and determine on its merits, it's hard to say. But yes, I think in principle, you're on the right lines there, Councillor Allison.
Thank you.
Thank you, Councillor Allison. Okay, if there's no further questions or comments, I will then summarise the points that have been made. The application is for planning permission for the erection of an equestrian stable block for private use, the formation of an access road with associated parking, turning area and fencing at Bigger Road in Symington. The adopted South Lanarkshire Local Development Plan 2 identifies the site as being within the rural area. If we consider that there is no valid policy justification to support the erection of a stable block and associated works at this location, and it would not accord with policies 15 and 29 of MPF 4 and policy 4 of the adopted South Lanarkshire Local Development Plan 2, permission can be refused. Or, if we consider that there is adequate justification for the erection of the stable block and associated works, we could grant plan permission subject to conditions. Our options here today are uphold, reverse or vary the planning decisions. I will now invite for any decisions and reasons. If there are no decisions or reasons, are members then minded to uphold the officer's decision to refuse planning permission? All agreed?
Agreed.
Is anyone else otherwise minded? Okay, therefore, the decision of the PLRB is to refuse planning permission as we are satisfied that the proposed development would be contrary to policies 15, 29 of MPF 4 and policy 4 of the adopted South Lanarkshire Local Development Plan 2. The next stage is that a written decision notice will be issued by the PLRB, and this should be issued within 28 days. Thank you. Agenda item number 6. We have no items of urgent business. I wish everyone a very good weekend. Take care and enjoy the weather. Thank you.